Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we discuss the property order attachment to the findings and order after hearing, also known as Form FL-344. This is a form that would be attached to a findings and order after hearing, that's an FL-340, if the court makes any sort of temporary property orders. A court would not make any sort of permanent property orders at a temporary hearing, such as a request for order hearing. Those would be done more likely at a trial stage, and there is a separate form that you would attach to a judgment. But for our purposes, we are talking about temporary property orders only. As with all our court forms, you want to fill out your identifying case caption information at the top, and then below are some of the types of orders that the court can make. A court can make some property restraining orders, in other words, orders that prohibit parties from selling or transferring assets. So specifically, if the court does make these type of orders, you want to mark the number 1 box, and then the orders that the court can make are to restrain a party from transferring, encumbering, hypothecating, concealing, or in any way disposing of any property, real or personal, whether community, quasi-community, or separate, except in the usual course of business or for the necessities of life. Basically, what that means is no transferring funds to a Swedish bank account, no buying a Ferrari at this point. You are able to use assets, but only in the normal course of business. The next type of property restraining order is to restrain or to require a party to notify the other party of any proposed extraordinary expenses at least 5 business days before incurring such expenses, and to make an accounting to a court. The next type of order that the court can make is to restrain a party from cashing, borrowing against, canceling, transferring, disposing of, or changing the beneficiaries of any insurance or other coverage, including life, health, automobile, and disability held for the benefit of the parties or their minor children. And finally, they can make an order that a party be restrained from incurring any debts or liabilities for which the other party might be held responsible other than in the ordinary course of business or for the necessities of life. So if the court makes any of these type of orders, you'd want to mark box 1 and then mark the box identifying the party that is being restrained or ordered to do a certain act. The second type of temporary order that the court can make is to make an order that one of the parties has temporary exclusive use and possession of property. That does not mean that they get that property forever and ever. It just means that until we can make further orders on how that property is to be divided, one party can have exclusive use to it. This often happens with homes and cars. If the court makes an order for a party to have exclusive use and possession of the home, often so they make that order just to keep the peace in the family and for the best interest of the children. So if the court does make that type of an order, mark box 2, and then under property, provide a description identifying the property. If it's a house, list the address. If it's a car, list the make, model, and year. And then under given to, list the name of the party that the asset is being temporarily awarded to. If there's a lot of assets, there's always an option to add an attachment. And if you do so, make sure to mark the box that says see attachment. 3, the court can make temporary orders for payment of debts. And again, these aren't common orders, but in certain cases, the court will order a party to assume payment for a debt where it is necessary to preserve assets for the benefit of the community being the husband and wife together. So if the court does make that type of an order, mark box 3, list the dollar amount of the debt that's being paid, the amount of the payments, that's the monthly payments, and who that payment is being made to, and which party is being ordered to make that payment. And again, if this is a very extensive list, you always have the option of adding an attachment, and if you do, mark the box. Again, more than likely, these are going to be temporary orders, so make sure to mark box number 4 that states as much. If there's any other order that's made that is in relation to property orders that's not specified above, you can mark box 5 and describe what that order is here. And again, this is a form that eventually will be attached to your FL-340, your findings and order after hearing, as you submit it to become part of a formalized order by the court. I hope you found this helpful. Good luck.